Good evening, everybody. I hope you guys can see me. Thank you so much for joining me for Trademarks 101, a webinar based on just trademarking in the United States. This is solely for the United States. I am not versed that well on international law to give a presentation about it, but I can help you and connect you with the people you need to go to. All right, here we go. So here is a little bit about me, your trusted speaker. If you don't know, of course, my name is Nequosha. That is pronounced Nequosha, the same Q sound as in quote. Say it with me. If you've been in some spaces and places with me, you know that's how I introduce myself. So there's that. So I am the founder and managing partner of Anderson Law Firm PLLC. I live where Mickey Mouse lives, so yay me. And the whole purpose of me finding, oh my goodness, talk mouth, finding Anderson Law Firm was on the principles of ensuring that creatives and people like you are securing their income producing ideas. Oftentimes, you will create something and you are not protecting it in the way that you probably should, and there's no shame in that. And I don't want you to feel like you are getting shamed. This is a safe space, okay? I am not a licensed mental health therapist or anything, but just know that this is a safe space. So if you are a business owner and you have not secured trademark protection, that's perfectly fine. You probably didn't know what it was for, but after tonight, you're going to be more educated on the thing. So a little bit more fun facts about me. I've been practicing for nearly 10 years. I've been doing trademarks a long time, so much that I was able to secure another client a $250,000 settlement over trademark infringement internationally. So trademark protection is very valuable and important to your business, and it's something that you need to make sure you have. Yes, 250,000 US of A dollars. So it is so important that you get this type of protection because it can help you in the long run. And another fun fact about me is I like pumpkin pie. I just had some pumpkin cheesecake the other day. So that's a little bit about me. So let's get into it. So tonight we are going to learn some basics of what is a trademark, what does it mean for my business to actually have one, why it's crucial, and should I make this type of investment? Is it necessary in Nequosha? We'll get into that. Then we'll talk about best practices, and then I'll open the floor up for you guys to ask me some questions, okay? Now, there comes the legal things that I must tell you because it's so important that I do. Number one, my presentation is copyrighted because I created it, and you know, as an IP attorney, you ain't finna steal from me, so try me if you want to. There's that. But the US government also says that I got protection. So again, don't try me, boo. Next up, this is a general advice type presentation. And I mean that with everything in me. You and me, by you watching this or participating in this, does not mean that we have attorney-client relationship. I'm very open to relationships and I value them. I like them a lot. But this particular relationship, unless some exchange of something, i.e. USD currency, has transpired, we do not have attorney-client relationship. So please don't confuse it. If you don't want to use me, that's fine. You can get a practitioner in the space where you live, where you not live, but use me because I'm friendly and I like you. You like me, right? Well, we'll get to that. So before we get into the heart, I know somebody who do like me. If you don't know, this is my mom. And my mom is one of the most inspirational people I know. And she always have told me the best business advice ever. And that is, do not go into business if you are not responsible, as you are bound to what? Fail and waste money and other people's time. This is what my mama always told me. So if you see my mama in the street, let her know that I am repping her to the day I die. All right. So there is my mom, the person who produced this. Love you, mama. So I want to ask you guys some questions because I'm not going to just be talking to the screen. That's not what I'm about. I want to hear from you. So I have a question and I want you to answer it. And I've created some handy dandy tools for you to respond back to me with polls. See, I didn't use the Zoom. I didn't with the Zoom trainer and they didn't taught me how to do these polls. So we're going to use the polls. So with that being said, I want you to answer this question for me. And that is, how many people really file for trademark protection? So I'm going to go ahead and launch this poll and I want you to answer it while I take a sip of the dip in this cup. All right. So go ahead and answer this for me and let me know how many people really file for trademark protection. Oh, I'm liking these answers. Oh, we almost got 100%. Come on, I'm gonna leave it up for a few more seconds. Come on, scragglers, answer the poll for me. I only got a few more. We at 73%. Okay. Ooh, this is interesting. This is interesting. This is interesting. Okay, I'm gonna shut the poll down in 5, 4, 3, 2, 1. All right. So I'm going to share the results. So some of you have said 1.5 million. Okay. 24% of you said 543,000. So a majority of you said only 250,000. Okay, that's interesting. Oh, and what time period? I'd say about a few years. I should have clarified that. Leave it to the other lawyers in the space to get some clarifying questions. I apologize. I will do better next time. But this is about an annual type thing. And about 10% of you said about 893,000. Okay, so let's stop the sharing. So I should have put some drum roll in this so that way it would have been a little bit more dramatic. But to answer your question, how many people really trademark their stuff? The data years that got this number was from 2003 to 2019. All right, lawyers in the space, 200 from 2003 to 2019, 893,000 trademark plus applications. Someone said in the chat, is it because of Shark Tank? It might be, I don't know, but so for you who answered 250,000, come on, we together in this, but that's a big number, right? Is your business in this number? We're gonna see. Maybe after? No. But let's get into it. So what is a trademark? A trademark is defined as a general word, phrase, symbol, or design that identifies and distinguishes the source of goods or services of one party from another. All right? That is the definition from the United States Patent and Trademark Office. And if you did secure trademark protection, you would have one of these things next to, you would be familiar with what this is. This, as you see on your screen, is the United States Trademark Actual Registration Certificate. So if you have achieved trademark registration, federal registration, you would get one of these in the mail once you got to that step. And it would have the registration number, it would have your owner's name, address, and the class that you actually have protection in. And I'll get into that a little bit later. And unlike some things who show you trademark, they blocked out people's address. Let me tell you, just like the registration for your business and the address, the name in most states, unlike Delaware, Arizona, Wyoming, some of them don't list the actual members. This public knowledge. So there's no reason for me to block this out because all you have to do is just go search it and it's going to come up. So that's a little pet peeve of mine, but that's neither here nor there. All right. So we just found out what a trademark actually is, but let's talk about what is not. Okay. What is not a trademark? A trademark is not a patent, okay? Patents are defined as scientific protection from scientific methods, processes, systems. That is not a trademark. What is not a trademark? A copyright. A copyright is federal protection. It's a protection tool, but it goes to something a little different. It is afforded to your ideas or works that are affixed to a permanent medium. Okay, when I say that, I'm talking photographs, I'm talking books, sheet music, graphic designs that you have written, stencil, journals, presentations, email funnels. These, the way you sync things in written permanent form or some permanent medium, CDs, music sheets, all of those things, copyright, not a trademark. You know what else was not a trademark? Let me sip this tea while I tell you. Your business name. Oh, don't hurt me. Your business name is not it's not a trademark. I don't care who told you that. I don't care all that. It ain't. That means that you could be Jay-Z Incorporated in the state of Florida. You could also be Jay-Z Incorporated in Georgia and be completely different and doing different things. I'm sorry. Look, don't be throwing nothing at me when you see me in the streets. Don't be telling me them people been lying to you. I'm sorry. They lying. I hate to be the one to tell you, but it's the truth. A trademark, it doesn't mean you are trademark protected because you have established an entity. A trademark is a separate protection tool that is totally different from you going to them people, department or corporation and registering your business name. Okay. Again, I put on this slide, and it's so important that we go over this. An LLC does not mean you have trademark protection. A trademark is a general word, phrase, or symbol or design that identifies and distinguishes the source of goods or services from one party or another. Not a business name, okay? Now, some of you are familiar with brands. Some of you may even have your very own brand. So this is another interactive layer of this presentation. Go ahead and drop it in the chat for me, some of your favorite brands. I want to see what some of y'all are getting down to. Don't overthink it. Just put your favorite brand in the chat. I want to see, okay, I see a Target, loves me a Target. I see Nike, Free People. Okay, y'all fancy. Apple, y'all got some big wallets over here. Mac, oh, okay, Patagonia. Okay, Trader Joe's. One time for the Trader Joe's. One time for the Trader Joe's. Okay. Madewell, Publix, Hershey's. Okay, YSL, Banana Republic. All right. All right. So some of you have some really, really dope brands that you have listed. And I bet you 99.9, well, we know 100% of these brands are protected. Even if they're not based in the United States, their business departments had enough insight to still seek out the trademark protection, because that is how powerful having this tool in your toolbox for your business is. It's so very powerful, so very powerful. Now, there are two distinctive types of trademarks. There are several others, but the ones we're going to focus on tonight is simply two. And I don't want to go into the weeds because, again, this is just a general overview. But the first one is called a word mark. And that's exactly what it is. A word mark is no graphics, no designs. It is simply the word. So when you come to a practitioner like myself, we're usually going to ask you, is it a word mark or is it the other? And we'll get into that in a second. So here on this slide, you'll see I put some pretty distinctive brands that just came top of mind for me. So Shea Moisture is a hair company. They do hair products and stuff. We're all familiar with the infamous Rihanna, Ella, A. So there's Rihanna. She, of course, has secured trademark protection, not only for Rihanna, but for Fenty and her Fenty brands as well, too. And then there is another brand called Megabus. If you've ever been on the East Coast, they go up and down and take you places. So they too, even a transportation company has secured trademark protection. So let's go to the next slide. Next up, the second thing, the primary trademark application you will see is called a design mark, okay? A design mark is simply that. It is a stylized something. So it could be stylized colors, it could be a stylized graphic. It is something that's distinctive, that's designed, graphics, all those things from a word mark, okay? Now, the way trademark protection comes into place is because there are 45 classes of protection. So that means you can be under a lot of things or just one thing. It don't really matter to me. The only way that you're going to get this, in the words of Janet Jackson, get behind the velvet rope, is you got to pay the filing fee. For each one of these 45 classes, a filing fee will attach. For instance, if you are doing, I don't know, consulting services, that would probably be class 35. But if you in your consulting business also would like to use your trademark on shirts and pants and all sorts of things like that, that would be a different class of protection, which would also mean you have to stand behind a different velvet rope, and that's a different filing fee. So it's sort of like when you go to a club, you know how to stand there, you got to talk to this bouncer to get in if he ain't your friend. Well, in this case, the USPTO has said, I don't care if we are friends, you're going to pay this entry fee. And the entry fee in this case is called a filing fee. All right. So we have now gone over the basics definition of what a trademark is. We have distinctive, the two types, a word mark and a design mark. But now your brain is probably kind of going, well, Nequosha, I've been in business. I don't really know if I should do this. I'm kind of new to business. Is this really the life I need to be living? Should I make this type of investment? Well, I got you, boo. This is probably why you're here. So why should you trademark your brand? Here we go. I was ready for you as that little meme go. I was waiting on you at the door. So here we go. A trademark never expires, asterisk, so long as you are using it and you pay the maintenance fees attached. You will have to show a continued use, but so long as you continue to use it, it will never, ever, 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 ever expire. So that means it can outlive you, all right? Number two, it makes it easier for your customers to find you. The whole purpose of having a distinctive brand is so when I see that Target bullseye, I know exactly what I'm getting, who I'm getting it from, what I can expect. And if I see somebody else with that bullseye and they don't really have that same feel to it, when I push the cart and it's not smooth, or the lighting, or it's a little off, that's going to make me question whether or not I'm really at a Target, even though I see that bullseye symbol. Another thing with trademarks is they are a good, effective communication tool. It lets the world in the United States, all 50 states, know that you cannot use my stuff, boo. Try me if you want to, but I got the United States government behind me, and they said that it's mine. All right. It's a good communication tool to others that you are the exclusive owner of this particular brand. Now, another reason is you will be a trusted brand source. Now, I kind of hit in on this when I was talking about the example with Target. You want your consumer to know that when they see your thing, your logo, your word mark, your whatever, they know that they're going to get a trusted good or service from you. They ain't even got to question it. It's like, we in like Flynn, I know what I'm getting. The other thing is, and this is probably one of the most important ones, having a federal trademark protection is a valuable business asset, okay? This is so valuable. This is like having currency. You know how I keep talking about paying me? Well, if you have a valuable brand and you have went ahead and secured trademark protection, Let me tell you, that's an asset. That is a commodity. That is something that you can use to your advantage. It can increase the value of your company. It can increase the value of your a whole plethora of things. And also, you could license it, but that's another story for another day. We're not talking about licensing. But another thing that you can do and you can have is that beloved R symbol next to your brand, because that R symbol means that you have secured federal trademark protection. Now, we did talk about the 45 different classes, and that is where the real strategy comes into place. You have to know whether or not you are a good or whether or not you are a service. So, what are goods? Goods are the products such as pens, shirts, cups, physical, something you can see, feel, touch, taste, right? Another thing is services. Now, services, you cannot touch them, you can't feel them, but you know they there. Sort of like that lover you used to have or your sneaky link. No judgment. But services are the things you perform for a benefit of somebody other than you, or your such as consulting or marketing services. Those are all, services related. Now, when you are ready and you want to do some more research, you go to the USPTO.gov website. Here is where all the magic happens, where you will pay your filing fee, where you could do some more searches about who has a trademark, who don't have a trademark. This is where the money resides, Okay, we go to the USPTO.gov. All right, this is where you go. Don't go to no other website. Don't let them people fool you on Al Gore's internet. If you want to know the real deal, this is where you go. Okay, promise me that you will not go nowhere else. So now you're probably like, you ready? I'm ready. She ready. I'm all ready. Like, I promise, Nequosha, I'm ready. Let's do this. I know where to go. I know there's 45 classes. I know I got filing fees. Let's do this, baby. Hold up, swole up. This is the part of the presentation where I want to ask you some more of them questions, all right? So let me know if you're ready for some questions. All right. So how many of you have done this before? I need to poll the room. How many of you have ever filed for a trademark? Go ahead. I'm going to launch this poll and answer it for me while I take a quick sip. All right. About a good portion of you. I'm going to leave it up for 5, 4, 3, 2, 1. All right. I'm going to end the poll. Let's share these results. So, okay, a few of you have won. All right. But most of you have never applied for a trademark. Okay, that's pretty good. Okay, I like that. You like that? I like that. All right, so one other thing that I would like to know at this stage is, since you have seen, your eyes have seen and your ears have heard about some of the benefits of having a trademark protection, I want to ask you this. Question. And do you see the value in having a relationship with an attorney and filing your trademark? So that's the question. I'm going to launch this poll, and it's going to lead to something. Just hear me out. It's going to lead to something. Just hear me out. Just go along with it, as the old folks say. You'll see in the end. All right. Some of you have said, yes, I see the value and I need an attorney to help me. And some of you have said, yes, I see the value, but I think I can do this myself. Okay. All right. Okay. You can do it yourself. Okay. That's what she said. All right. So we're going to end this poll. I'm going to share this results. So a good portion of you are on the right track. Most of you have said that you see the value and you need an attorney to help you. And then some of you, 2 of you have, about a few of you, 9% of you have said you see the value, but you think you can do it yourself, okay? And in the chat, someone says, as an attorney in another area of law, there ain't no way I'm trying to figure this out myself. You smart. Someone else says, as a photographer who has had to sue someone, hell no, I'm not doing this myself. I would never DIY. And someone else said, I could try to do it myself, but why? Somebody said, I literally just got an email from the USPTO from what I submitted for 2 of my logos, and they said I need some changes. Oh, girl, I could kiss you. Let me tell you, you must have got a hold of my slides. You must have got a hold of my slides, because less than 50% of trademark applications filed without an attorney fail. Ooh, ooh, ooh. I'm gonna leave this up for a few more seconds. Yep, you read that right. Less than 50%. That means you basically have a good chance of just throwing your money down the drain. You literally just gave the government some free money. Some free money, okay? I mean, I ain't telling you no tales, the statistics ain't lying. Look, somebody said, listen, I am a whole witness. She ain't lying. As the old folks say, she ain't lying. So here's the real Holyfield deal when it comes to filing a trademark. Most people will just start at stage 1 and they'll do a little Google search, okay? And then that's where they stop. That's where they stop. Oh, I ain't find it on Google, Nequosha, I'm good. Let me go trademark this. Or if they have a little bit of education on their side, they will go to the uspto.gov website and do a test search, okay? A test search. They'll do one of those, all right? However, comma, that ain't where you stop either, boo. That ain't it. As a practitioner in this space, I am afforded the opportunity to have access to knockout clearance databases. That means we do a little bit more comprehensive search than going to Google or simply just going to the test database on the uspto.gov. We have access to some other tools that you don't even know about, all right? Now, once we get past that searching, and that is so important, because in searching, we will determine whether or not your trademark is actually distinctive, whether or not your trademark could actually have a good chance of federal trademark protection, and whether or not somebody else is already using your stuff, boo. And on that, I'm a sip. Because what most people don't realize is in trademark protection, it's not the first to create, it's the first to file. It's the first one who got to the door, opened the door, paid the filing fee, and did what they were supposed to do. Now, that doesn't mean these people actually have viable usage, meaning they have proof of they're using your trademark or your brand or those things. But guess what the USPTO is gonna say? Well, I don't really know who to believe, but they filed first, so I'm gonna kind of go with that side until you prove me different. So that means you're gonna be spending more money defending something that you created, something that your blood, sweat, tears sitting at your kitchen table with snacks and the things you like, clacking away on your computer or developing your physical product, nail gluing, whatever y'all use, cricketing, all that Etsy stuff y'all be doing. Somebody else said, ooh, they didn't do what they supposed to do. Let me get to the dough. And they went to stage 2. They went to the uspto.gov. They paid the filing fee. They did the class of protection in the same class that you would be in. And then they did this. I'll wait. They waited the appropriate months. You, unbeknownst to you, you just carrying on, selling your stuff, pushing your stuff on social media. And these people then went and achieved federal trademark protection with your stuff. What you gonna do? What you gonna do? How does that make you feel? Go ahead in the chat and let me know how you would feel if you found out someone has trademarked your brand. Let me know how you feel. Somebody said furious, pissed, dumb. That's some bull crap. Somebody else said, come outside. Okay, come outside. Like, no questions asked. Foolish. Somebody said, I can't answer because I'm saved. I love that. I can't answer because I'm saved. All right. All right. But for those people who said that 9% who said that they could do it on themselves, do you see the value? Do you see it now? Go ahead and let me know. Do you see the value? Catch me outside. Okay, that's exactly what I'm saying. Like, it ain't no questions. It ain't you gonna catch me outside, boo. Because that's a problem. And that is a major, major, major problem. I definitely would not want to do it myself either. Knowing what I know, I wouldn't do it myself. So again, this is my advice to you. You may not like Cardi B, but she be spitting facts sometimes, asterisk, sometimes. No, 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 no. You do not want to do this by yourself. You do not want to do this by yourself. Did I say you didn't want to do this by yourself? Because I think I said that, right? Because guess who else knows that you didn't do it by yourself? The examining attorney. The examining attorneys at the USPTO actually encourage all applicants when they issue office actions is how they communicate that something is wrong with your application. They communicate by telling you, we encourage you to seek out counsel. They even put it in their message to you because they can tell. They know when you ain't did it because one, an attorney is not listed. Okay. So I brought this back because I wanted to be top of mind. Top of mind. Less than 50% of trademark applications applied for without an attorney fail. I'm gonna let that marinate while I take a sip. Less than 50% of trademark applications applied for without an attorney will fail. It's true. It's the truth. Now, I know some of y'all are like, I don't want to be serious. I waited too long to do this. I don't want to be caught out here slipping. I don't want to be furious. I don't want to be calling on Jesus because I'm about to lose my religion because somebody then took my brand. I get it. I understand. I get it. Because I too would be upset. But I want you to know you can have a partnership. You can have somebody in the trenches with you. You can leverage the experience and counsel of somebody to help you in this experience. I can help you create the best application the first time, not the second time, but the first time. We can go through the 45 different classes and do an analysis to make sure that you are where you are supposed to be. That's the type of partnership that you could have if it's on my website, or you can send me an email, or you can call me. In the words of Tweet, oh, when you need me, baby. The phone number is there. My email is there. My website is there. I'm on Instagram at Esquire44. I'm in these streets. You can find me, okay?